Okay, so this statute, the Wisconsin self-defense statute, touches upon most of the elements of self-defense, but not all of them, which you might find surprising. And partly that's because some of the elements of self-defense are found not in statute, but in case law. There's really two forms of law: statutory law created by the legislature and case law created by appellate courts. They're both equally valid. Neither one is weaker than the other. So it's very important when you're considering the use of force law in your state that you consider not just what's said in a statute, but also what's said by the appellate courts. In fact, a plain English reading of statutory language can be quite dangerous because statutes don't necessarily mean what they appear to mean. Statutes mean what the courts say they mean. So the legislature had some intent and purpose in how they drafted a legislation that's made into law. But statutes by themselves have no effect in the real world. They don't have any effect. They're just words on paper. They don't have any effect in the real world until those statutes are being applied by a court to real parties in a courtroom. And the court is making interpretations of that statute. And it's not uncommon for courts to interpret statutes in ways that are different than the apparent plain English reading of the statute. Sometimes they read additional conditions into a statute, or they appear to read conditions out of a statute. And the only way to know that is to have read the appellate court cases that interpret and apply that statute. A useful way of doing this without having to read all the appellate case law is to go look at the jury instructions. Jury instructions are not themselves an authoritative source of law, but they're very useful in the sense that they tend to be an amalgamation of the statutory language and how the courts want that statutory language applied. Generally, the jury instructions are created by the Supreme Court of the state, putting together panels of legal experts, prosecutors, defense attorneys, legal scholars, and they devise a set of standardized jury instructions that are supposed to be applied on a consistent basis from trial to trial. And because they do combine the statutory language and how the courts want it applied, if there's any case law that would add conditions or remove conditions from statutory language, we tend to see those reflected in the jury instructions. So let's take a look at some of the jury instructions. Here's one, jury instruction 805 for Wisconsin. Self-defense. So this is literally an instruction read to the jury by the judge at the end of the trial, explaining to the jury how to apply the law to the facts of the case as they believe those facts have been proven. The judge is the finder of law. He tells the jury what the law is and how to apply it. The jury is the finder of fact. They listen to the testimony, the evidence, and so forth, and they make determinations of what facts they believe to have been proven or not proven. Now, I should come back to the burdens here. Most of us are familiar with the concept of a burden of proof. Of course, in a criminal case, the burden of proof is on the state to prove the crime beyond a reasonable doubt, each and every element of the crime, beyond a reasonable doubt to the satisfaction of the jury. And interestingly, in a self-defense case, this also applies to the issue of self-defense, but in a negative way. So once self-defense is an issue at trial, the state not only has to prove the elements of the crime beyond a reasonable doubt, the state also has to disprove self-defense beyond a reasonable doubt. Now, they don't have to prove the entirety of self-defense. Remember, these 5 elements we talked about, they are cumulative. They're all required. If anyone is missing, there is no self-defense. So the state knows this, of course. They know they're in a self-defense case. So the state perceives every one of these elements as a target of attack. If they can effectively disprove any one of the required elements beyond a reasonable doubt, they've disproven self-defense. And this is true in all 50 states and true in Wisconsin as well. Importantly, this burden on self-defense for the state to disprove self-defense beyond a reasonable doubt, the burden of persuading the jury on the question of self-defense, that burden of persuasion does not shift to the state until the defense has already met their burden of production. The burden of production is how you get the issue of self-defense into a courtroom in the first place. As a defendant, you don't have some automatic right to argue self-defense in trial. You have to qualify to argue self-defense. How do you qualify? By meeting your burden of production. How do you meet your burden of production? What does that mean? That means there has to be in the evidentiary record some evidence to support each of the required elements of self-defense. It doesn't have to be a lot of evidence. It can be a scintilla of evidence. It can be contested evidence. But there has to be more than zero, because remember, all a jury does is consider facts, consider evidence. If there's zero evidence, there's nothing for the jury to consider. If there's zero evidence, literally zero evidence on any required element of self-defense, well, the jury can't find that element to exist in the complete absence of evidence. So there has to be some greater than zero amount of evidence in favor of each element. If that's not the case, if there's literally zero evidence in favor of any element of self-defense, well, then you haven't met your burden of production, and you can be denied the right to argue self-defense at trial. Or if you are allowed to argue self-defense at trial, at the end of the trial, you can be denied a self-defense jury instruction. And if the jury doesn't get a self-defense jury instruction, they can't acquit you on the grounds of self-defense. Now, it's quite possible here, I've heard that there have been a motion filed by the state to deny this defendant perfect self-defense, a perfect self-defense jury instruction, and limit him to at best an imperfect self-defense jury instruction. When such motions are filed, what typically a trial judge will do is say, well, listen, I'm not going to decide this issue now because evidence is developed over the course of the trial. And remember, the judge doesn't really know the evidence until he's heard it in his courtroom, typically. We'll see how the evidence develops over the course of the trial. I will allow the defense to argue self-defense. At the end of the trial, when everyone's rested, I'm going to look at the evidentiary record and make a determination then of whether the burden of production has been met. If it's been met, I'll give you the perfect self-defense jury instruction. If it hasn't, the most you can hope for is imperfect self-defense and mitigating murder down to manslaughter. I expect that's probably what will happen